The United States District Court for the Northern District of California fell into a heavy, expectant silence as Judge Edward Chen leaned forward, a faint, almost mischievous smile tugging at the corners of his mouth. The wood-paneled courtroom, steeped in the formality of federal proceedings, was packed wall to wall. Journalists, legal analysts, and curious spectators squeezed into every available seat, their eyes locked on the defendant's table where Elon Musk sat motionless. His face was a masterclass in stoicism, blank, unreadable, as the 70-year-old federal judge prepared to address his legal team's latest argument. "Mr. Musk," Judge Chen began, his voice cutting through the charged stillness with absolute clarity. "You've argued that your funding-secured tweet was merely aspirational, that no reasonable investor would have taken it literally." A slight shake of the judge's head followed, slow and deliberate. He paused, surveying the courtroom, then spoke again, this time with a tone that carried unmistakable disdain. "That argument isn't just wrong," he said, pausing for effect. "It's absurd enough to be laughable." And then, to the astonishment of everyone present, Judge Chen actually laughed, a short, sharp chuckle that echoed off the courtroom walls like a gunshot. Pens hesitated over notebooks, glances shot between seasoned journalists. This moment was extraordinary, historic even. Federal judges, especially those of Chen's stature, rarely, if ever, displayed open mockery toward a defendant, let alone toward one of the world's richest and most powerful men. Across the courtroom, Musk's attorneys shifted uncomfortably. Papers rustled, urgent whispers broke out between them. Yet Musk himself didn't move a muscle. His face, though still outwardly composed, flushed a shade darker. Behind his fixed gaze something shifted. Not merely anger, but something colder. Calculation. Judge Chen continued, his voice steely. "This court will not permit the CEO of a public company to casually redefine securities law to suit his own ends. Your wealth and your fame, Mr. Musk, offer you no special shield here." It was a stunning rebuke, and it reverberated through the courtroom like a physical blow. In that moment it became clear. Musk's usual weapons on charisma, fame, and audacity would find no traction in Judge Chen's domain, and yet, what unfolded next would shock even the most jaded legal observers. Within 24 hours, Elon Musk would make a move so brazen, so unpredictable, that it would ripple not only through the American legal system, but also through the financial markets, the tech world, and social media, leaving legal scholars and commentators alike scrambling to catch up. Before we dive into the shocking maneuver Musk executed, a move that would redefine the trajectory of the entire case, take a moment to like this video and subscribe to our channel. We bring you breaking news, behind-the-scenes analysis, and in-depth coverage of the legal battles shaping our world. Turn on notifications so you don't miss a single update. Now, back to the extraordinary clash that shook the courtroom. The collision between Judge Edward Chen and Elon Musk wasn't merely a legal skirmish. It was a philosophical confrontation between two vastly different ways of thinking. Judge Chen, a Harvard Law graduate appointed to the federal bench by President Barack Obama in 2011, had earned a reputation as a jurist's jurist, methodical, reserved, and uncompromisingly by the book. His courtroom was known for discipline, adherence to strict legal procedure, and absolute impartiality. Grandstanding found no purchase here. Celebrity wielded no special influence. Judge Chen runs one of the tightest courtrooms in the Northern District, noted legal analyst Sarah Michaels. He's respected because he's thorough and fair, but he has zero tolerance for attempts to use public pressure or spectacle to manipulate the judicial process. Facing him was Elon Musk, the ultimate agent of disruption. Born in South Africa, Musk had upended not one but several entire industries. Electric vehicles with Tesla, private spaceflight with SpaceX, and digital communication platforms with X, formerly Twitter. His career was built on flouting conventional wisdom, ignoring regulations, and forging ahead with sheer willpower. Musk's 126 million social media followers didn't just admire him. They treated his every word as gospel. Musk operates on the belief that rules are for people without the vision to change the world. Tech journalist Robert Chen, no relation to the judge, observed. That attitude made him the richest man on earth. But it's precisely that same attitude that the judicial system exists to check. Their clash was inevitable. At the center of this legal maelstrom was Musk's infamous 2018 tweet, "Am considering taking Tesla private at 420. Funding secured." The tweet immediately sent Tesla's stock price skyrocketing, only for it to tumble when it became clear no such funding had actually been secured. Shareholders claimed billions in damages. The Securities and Exchange Commission, SEC, had already forced Musk to resign as Tesla's chairman and to pay a $20 million fine. But this civil case threatened far worse: personal liability and potentially crippling financial penalties. Musk's defense, that no rational investor would have taken his tweet seriously, was in Judge Chen's eyes not just legally flimsy, but an affront to the very principles of market transparency that securities law exists to protect. As Musk sat there processing the stinging public rebuke, few could have guessed what was coming next. Instead of playing by the traditional rules, issuing a contrite statement, allowing his lawyers to negotiate quietly behind closed doors, Musk would do something nobody expected. He would take his battle public. He would double down. He would defy not just Judge Chen, but the very concept of courtroom decorum, unleashing a sequence of moves that would throw the entire case into disarray, electrify his followers, rattle investors, and challenge the federal judiciary's ability to contain one of the most powerful forces of the modern era: Elon Musk's refusal to be controlled by anyone but himself. Stay tuned, because the story of Musk versus the legal system is just getting started. And if history is any guide, the most unpredictable moves are still yet to come. The case unfolding before Judge Edward Chen was about far more than one billionaire's tweet. It was a fundamental test of whether securities laws still held power over the ultra-wealthy and influential in the age of social media. For Judge Chen, the stakes were enormous. His reputation for impartiality, and by extension the integrity of the American legal system, was on the line. For Elon Musk, however, the stakes were even more personal. A ruling against him wouldn't just cost billions in damages. It would validate his critics' portrayal of him as reckless, unreliable, and dangerously unbound by rules. It would strike a devastating blow to the carefully cultivated image of visionary genius that underpinned his sprawling business empire. This isn't just about money for Musk, explained business psychologist Dr. Miranda Jones. It's about identity. Judge Chen's laughter earlier that morning had hit Musk somewhere deeper than his wallet. It challenged his self-image, not as a rule breaker, but as someone who rewrites the rules altogether. As the courtroom tension escalated, observers began to notice a subtle but telling change in Musk's demeanor. The first flash of anger that crossed his face slowly melted into something far colder, more calculating. Those who knew Musk recognized the look instantly. It was the same expression he wore before announcing plans to land rockets on floating platforms, or to tunnel beneath Los Angeles traffic. When most people get humiliated in court, they retreat, said a former Tesla executive, speaking on condition of anonymity. When Elon feels cornered, that's when he's most dangerous. That's when he makes moves no one sees coming. Meanwhile, Judge Chen continued his methodical dismantling of Musk's defense, seemingly unaware, or unconcerned, that the billionaire across the courtroom was already formulating a response that would upend not just this case, but the very playbook for how high-profile litigation could be fought in America. The tension in the room ratcheted even higher as Judge Chen shifted from a moment of rare laughter to a full-throated legal takedown. His tone grew firmer as he turned, his focus to Musk's lead attorney, the renowned securities lawyer William Adamson. "Counsel," Chen said sharply, removing his glasses for emphasis. "Your argument fails on both legal and logical grounds." He paused just long enough to let the words sink in, then continued. Mr. Musk's tweet was not vague futurism. It cited a specific price point and claimed funding secured as a present fact, not as an aspiration. Adamson attempted to interject, but Judge Chen raised a hand, silencing him with the authority that only years on the bench can confer. "This court is not finished," Chen said coolly. "I have reviewed the evidence thoroughly, including Mr. Musk's subsequent communications. The pattern is clear, not a misunderstanding, but a deliberate attempt to influence markets through misleading statements." Journalists' pens flew furiously across notepads. In the gallery, a few Tesla shareholders, plaintiffs in the class action lawsuit, exchanged satisfied, knowing glances. Their lead attorney, Victoria Reynolds, maintained a polished poker face, but the slight curve at the corner of her mouth hinted at growing confidence. Through it all, Musk remained remarkably silent. Occasionally, he leaned toward his attorneys for a whispered exchange, but he displayed none of his usual impulsivity. No muttered sarcasm, no outbursts, no cryptic smirks. For a man known to respond to challenges with inflammatory tweets and combative interviews, this controlled, calculating stillness was jarring. "I've covered Musk for years," tech reporter Carlos Mendez whispered to a colleague. "I've never seen him this restrained. Something's different." As the morning session dragged on, Judge Chen meticulously cited precedent after precedent, each one closing another potential legal escape hatch for Musk's defense. He referenced SEC regulations, prior cases involving misleading executive statements, and the undeniable market effects of Musk's funding-secured claim. "The court takes judicial notice," Chen stated firmly, "that Tesla's stock rose 11% following the defendant's tweet. That represents billions of dollars in market movement based on what Mr. Musk now claims was casual wordplay." He looked directly at Musk's table before delivering the hammer blow. "The securities markets cannot function if CEOs are allowed to manipulate billions in shareholder value, and then later excuse it as mere aspiration." By the time the court recessed for lunch, legal commentators were already delivering a near-unanimous verdict outside the courthouse. "Musk is staring down an almost certain defeat," said legal analyst Patricia Torres, speaking to a throng of reporters. "Judge Chen has methodically closed off every conventional line of defense. If this continues along traditional paths, Musk faces a potentially catastrophic judgment." But what Torres, and almost everyone else, failed to realize was this: Elon Musk had no intention of continuing along any traditional path. During the lunch break, while Musk's legal team huddled in a side conference room frantically reviewing their dwindling options, Elon Musk sat alone. Eyes locked on his phone, he ignored food, waved off concerned assistants, and made a series of brief, clipped phone calls. When his chief attorney finally approached, offering a revised legal strategy, Musk didn't even look up at first. He simply shook his head. "We're not going to out-lawyer a judge who's already made up his mind," Musk said quietly. "It's time to change the game entirely." "Elon, I strongly advise against whatever you're thinking," attorney William Adamson said, recognizing the dangerous resolve in Musk's voice. "The conventional approach might not be exciting, but the conventional approach has us losing," Musk interrupted sharply. "And I didn't get where I am by being conventional. When the standard path leads to failure, you build a new one." He held out his phone to Adamson. The attorney's face paled as he read the screen. "You can't be serious," Adamson whispered. "This would violate every protocol." "It violates no laws," Musk replied, calm as ever. "And sometimes when the framework guarantees defeat, you don't just fight within it. You reframe the problem." As the bailiff called the court back into session, Musk returned to the defendant's table with a newfound air of calm confidence that puzzled everyone in the room. Judge Chen, noting the shift, studied Musk with narrowed eyes. No one in that courtroom could have predicted what would unfold in the next 24 hours. A move so audacious, it would force a complete reassessment of how high-stakes corporate litigation worked in an age of social media and billionaire influence. As the afternoon session resumed, Judge Chen looked poised to continue methodically dismantling Musk's legal defenses. But before Chen could speak, Musk rose suddenly to his feet. "Your Honor, I respectfully request permission to address the court directly," Musk said, ignoring the frantic tugging at his sleeve from his attorney. The courtroom froze. Defendants, rarely spoke without being directly questioned. It was almost unheard of for one to bypass counsel entirely. Judge Chen hesitated. Then, curiosity overtook protocol. "This is highly irregular, Mr. Musk," Chen said, peering over his glasses. "But under the circumstances, I'll allow it. Proceed." What followed wasn't the defensive technical argument everyone expected. Instead, Musk spoke with startling candor. "Your Honor, you laughed at my defense earlier today, and perhaps rightly so," Musk began, his voice steady and clear. "I reflected on that during recess. Rather than continue offering legal arguments that clearly aren't persuading this court, I'd like to propose something unprecedented." A stunned hush fell over the courtroom. Musk continued. "Within 24 hours, I will personally create a $3 billion restitution fund, significantly more than the plaintiffs are seeking, to compensate any investor who can demonstrate genuine financial harm from my funding-secured tweet. This fund will be independently administered with no strings attached." Gasps and murmurs rippled through the courtroom. Judge Chen banged his gavel for order, his expression a mixture of shock and skepticism. Musk pressed on. "Additionally, I will establish a $2 billion trust, dedicated to enhancing SEC securities enforcement technologies and investor education initiatives. And finally," he paused for effect, "I will surrender my personal Tesla stock options for the next 3 years, redirecting them to Tesla's factory workforce." At the plaintiff's table, attorneys huddled in a burst of urgent, whispered conversation. Across the gallery, jaws hung slack. Even seasoned court reporters struggled to keep up. Musk concluded, "Your Honor, I could spend years fighting this case, dragging out appeals, draining judicial resources, delaying any real resolution. Instead, I'm offering immediate, tangible accountability at a scale no court judgment could match." He stepped back from the podium, hands steady at his sides. For a long moment, Judge Chen said nothing. The courtroom had never been so silent. "I only ask," Musk continued, "that in exchange, the court allow me to acknowledge my mistake without a formal finding of securities fraud, a finding that would trigger automatic consequences for my ability to lead my companies." Judge Chen, clearly working to process the extraordinary turn of events, leaned forward. "Mr. Musk," he said slowly, "are you representing that you have the authority and means to implement these proposals immediately, without needing board approval or other corporate governance procedures?" "I am, Your Honor," Musk replied without hesitation. "The fund transfers will begin by midnight tonight, regardless of the court's decision. This isn't contingent on acceptance. It's a commitment I'm making. Period." Judge Chen called for an immediate recess, instructing both parties to document the proposal in writing before he would even consider it formally. Outside the courtroom, stunned legal analysts scrambled to make sense of what they had just witnessed. "Musk has essentially created a third option," explained Harvard law professor Eleanor Burke to a huddle of reporters. "Where conventional wisdom saw only two, fight and likely lose or settle traditionally, Musk has invented a third path. He's offering restitution at a scale that renders the legal battle almost pointless, while avoiding the specific finding that would personally damage him most. It's brilliant, if completely unorthodox." 3 hours later, when court reconvened, it was clear Judge Chen had spent the recess digging deeply into the mechanics of Musk's offer. He questioned Musk exhaustively about the governance of the proposed funds, the verification process for investor claims, and how independent oversight would be ensured. Musk, uncharacteristically patient and precise, answered every question thoroughly, a clear sign he had used the break to prepare meticulously. Meanwhile, the plaintiff's attorneys found themselves trapped in an impossible dilemma. Fighting against Musk's $5 billion offer would make them appear more interested in a legal victory than in securing actual restitution for harmed investors, precisely the narrative they couldn't afford. After a final round of clarifications and adjustments, Judge Chen delivered his ruling. This court finds that Mr. Musk's proposal satisfies the fundamental aims of securities legislation: investor protection, market integrity, and meaningful accountability, he stated. While the approach is unconventional, the substance exceeds what could reasonably be achieved through traditional remedies. As the terms were formalized, legal observers watched in amazement. Musk had transformed a near-certain defeat into a kind of triumph, not by winning the legal battle, but by rendering it irrelevant, using a flanking move of unprecedented scale and boldness. What we just witnessed wasn't traditional legal brilliance, commented James Donovan, an SEC attorney turned analyst. It was the application of Musk's business philosophy to the courtroom. When defeat seems inevitable under the rules, change the rules by acting on a scale no one else can match. As Musk exited the courthouse, his expression wasn't one of victory, or even relief. It was something colder, more calculated, satisfaction. The man who had been laughed at by a federal judge just hours earlier had once again rewritten the playbook. The aftermath. The shockwaves from Musk's courtroom gambit spread at the speed of a digital wildfire. Within hours of the court's acceptance of his unprecedented proposal, hashtags like Musk Justice Fund and billionaire accountability were trending worldwide. Video clips of Musk's exchange with Judge Chen racked up over 50 million views across social media platforms as pundits, legal scholars, and everyday citizens debated the stunning implications. The Wall Street Journal ran a headline the next morning: Musk rewrites the legal playbook. The New York Times opted for a more cautious take. Unprecedented settlement raises questions about wealth and justice. Meanwhile, tech media zeroed in on Tesla's soaring stock price, which jumped 4.7% in the immediate aftermath of the deal. Financial news networks ran nonstop coverage with panels of securities attorneys and business ethicists dissecting the move from every angle. CNBC dubbed it the billion-dollar courtroom chess move. Bloomberg pushed special analysis to subscribers about the potential long-term impacts for shareholder lawsuits against powerful executives. One key takeaway emerged: Musk hadn't evaded the traditional legal framework. He had simply overwhelmed it, demonstrating that for the ultra-wealthy, accountability could be reshaped, not through trickery, but through sheer, unimaginable scale. Constructive action, explained Yale law professor Miranda Cho on CNN, is neither clearly good nor bad for our legal system. It's simply unprecedented. As expected, social media reactions split sharply along familiar lines. Musk's supporters hailed the move as further proof of his brilliance and commitment to disruptive innovation. He literally just solved a legal problem the way he solves engineering problems, with scale, speed, and out-of-the-box thinking. Tweeted a prominent tech influencer with over 3 million followers. Critics and skeptics saw it differently. To them, Musk hadn't innovated. He had bought a better outcome. Today we learned the exact price of different justice if you're worth $200 billion, wrote Senator Elizabeth Warren. The question isn't whether harmed investors were helped. They were. The question is whether our legal system should have different rules based on wealth. Meanwhile, across Silicon Valley and in corporate boardrooms nationwide, executives and their legal teams scrambled to dissect what quickly became known as the Musk maneuver. Law firms specializing in corporate defense rushed out client memos analyzing the potential and limitations of this strategy. A widely shared analysis from Davis and Harmon LLP laid out 3 essential preconditions. First, extraordinary personal wealth that allows for settlements far exceeding probable court judgments. Second, leadership roles where the individual's continued presence is more valuable than any monetary cost. Third, a rare willingness to accept personal responsibility, something most corporate defendants fiercely resist. For the shareholders who had initiated the lawsuit, the outcome was bittersweet. The new compensation fund offered faster and far more generous restitution than they could have hoped for after years of litigation. Yet, a sense of lost principle lingered. The money is certainly welcome and exceeds our financial expectations, admitted Marcus Reynolds, one of the lead plaintiffs, in an interview with Bloomberg. But there was also a principle at stake about transparency and accountability that feels somewhat sidestepped by this resolution. As for Judge Edward Chen, who had laughed at Musk's original legal posture before ultimately endorsing his radical settlement, he found himself unexpectedly thrust into the public spotlight. Legal blogs and law journals erupted with debate. Had Judge Chen capitulated to Musk's wealth? Or had he pragmatically secured the best possible outcome for injured investors? The judge himself maintained strict silence outside his formal rulings, but sources close to him suggested he viewed the outcome as imperfect, but superior to any realistic alternative. Judge Chen is, above all, a practical jurist, said a former clerk speaking anonymously. He recognized that the goal of securities law is investor protection, not punishment for its own sake. Within the SEC, urgent internal meetings were convened. The $2 billion enforcement fund Musk had pledged massively boosted the commission's resources, but it also raised thorny questions about private funding of regulatory efforts. Interim guidelines were hastily drafted to ensure the SEC maintained independence while utilizing these unprecedented resources. More broadly, Musk's gambit triggered an uncomfortable but necessary conversation about justice in an age of staggering wealth inequality. Law schools rushed to organize symposia. Harvard Law Review published a special feature on what it dubbed plutocratic procedure, asking what happens when billionaires can reshape legal remedies. Congressional committees announced hearings on whether new legislation was needed to ensure laws applied equally regardless of personal wealth. For Musk himself, the fallout was both vindicating and challenging. He had avoided the most damaging outcomes, but he had also solidified an image for better or worse, as a man who played by different rules. True to his word, Musk's restitution fund was established with astonishing speed. The first investor payments were processed within a week, an unheard-of timeline compared to the typical years-long slog of class action settlements. At Tesla headquarters, the atmosphere was one of cautious relief. Executives who had braced for endless litigation distractions now turned their focus back to operational challenges. Musk's decision to surrender stock options to factory workers created logistical complexities but proved popular among production staff, a key to hitting aggressive delivery targets. 3 weeks after the courtroom showdown, Musk and Judge Chen crossed paths again at a high-profile legal charity dinner in San Francisco. It was their first encounter since that fateful day. Witnesses described an initially tense but ultimately respectful conversation. What struck me, recalled event chair Patricia Coleman, was how they seemed to reach a kind of mutual understanding. Two brilliant minds approaching the same problem from totally different frameworks, and somehow finding a resolution that neither could have designed alone. As the dust settled on this extraordinary saga, one truth became clear. The day a federal judge laughed at Elon Musk had not ended in humiliation, but in the opening of a new, still evolving chapter in the relationship between extreme wealth, traditional legal systems, and the very meaning of justice in the modern world. Thank you for watching our in-depth analysis of this groundbreaking legal confrontation between Judge Edward Chen and Elon Musk. If you found this breakdown valuable, please hit the like button and subscribe to our channel. Turn on notifications so you don't miss our upcoming exclusive interview with one of the key legal experts behind Musk's unprecedented settlement. And drop a comment below. Do you think Musk's approach represents bold innovation or a troubling new precedent for justice?